Please, Your Lordship. Lordship, I beg to mention item numbers 5 and 6 of the daily list. Conducting counsel Mr. SN is on sanction leave, my lord.
You are for?
This matter actually has already become infructuous. So whatever relief they have sought for, it was against the former Sima Malim. He has already expired.
Oh, yes, yes. I think
Same.
you're supposed to seek instruction, I think.
Yes, my lord.
Yes, but unfortunately my senior is on sanction leave, Your Honor. It may be taken up on the next date.
Any instruction can always be relayed to you.
Yes.
What is there? If there is any more, as Mr. Kriamat said, if any cause of action survives,
Nothing survives actually.
court will look into it.
Well.
But if nothing survives, it's pointless just keeping it from one date to another date.
All relief has been sought for against the deceased person, my lord. Whatever relief that has been sought in the
suspension issue
his
and all
suspension, his resignation, my lord. So nothing survives now, my lord, after the expiry of the...
Have you brought this death on record?
Yes, my lord, we have filed an affidavit. We have filed, my lord.
You have filed?
We have filed, my lord. This was filed on 6th December, my lord. It's on
We have
report,
received a copy.
They have received also the copy.
In that case, okay, we'll keep it next week.
Yes, ma'am.
If the petitioner chooses not to pursue with the matter, what else remains? Nothing remains.
Well, let it be after 14.
You will be struck off automatically.
He has already been struck off as of now, my lord.
Okay, we'll keep it next week.
After 14, my lord, otherwise it
17th.
17th, my lord.
On payment by the parties, list this matter after on 17th.
Obliged.
So,
Supplementary list, item number 1.
Yes.
Lordship, this bail application which has been filed by the petitioner, who is the father of the accused. Your Honor, in this matter, the accused was arrested on 22nd of August 2024, and the complainant is the SI Light Pars Aim of Ratachira checkpost. He has launched the FIR, Lordship, in this matter regarding the while he was doing the checking in the checkpost for the illegal migration, was entering the state of Meghalaya. He was found he found this accused, Your Honor, to be suspicious of carrying illegal consignment. Therefore, he has filed an FIR registered under this registered White Umkyang PPP White GDE number 9 dated 22nd 8/2024 and was forwarded to Shnong PS under section 321B 29 NDPS Act. Your Honor, in this matter, the accused was arrested on the same particular day only, and Your Honor, actually what happened was that the accused was asked by the applicant, which is the father of the accused, to go and check one truck, Your Honor. The applicant's truck was severely damaged due to accident on the before the arrest of the accused, Your Honor. The registration of this registration number of this truck was ML05S06 for 6, Your Honor. It was it met an accident near near Silchar. On the way to Silchar, it met an accident. Therefore, the accused was sent by his father, who is the petitioner in this matter, to check the truck regarding the repair work, Your Honor. And therefore, he went there. He took early morning on 20th August, early morning, he took a truck, or he took a sumo vehicle from Shillong. He went to that particular place. So he had to take the sumo from Silchar, which goes, or from Shillong, which goes to Silchar. Therefore, Your Honor, after finishing the work, he wanted to come back with the sumo itself, some other sumo vehicle which comes from Silchar, but he could not get any sumo coming from there. Therefore, he took a bus, a night super bus, to come this side, Your Honor. And therefore, while entering the bus, he saw one empty seat. Therefore, he went and sat on that seat. But unknowingly, the seat, under the seat, there's a brown curtain was there, which was some suspicious. This consignment was kept. He was unknown regarding that, Your Honor. He was totally unaware of it, without his knowledge. But on the 22nd itself, early morning, the bus was stopped in this checkpoint. Therefore, some police, where it was headed by this SI Lordship, SI Light Parts Aim. Therefore, he had undergone a checking, and therefore he found this accused to be suspicious, and therefore Therefore, after seeing he found this accused to be suspicious, and after finding this curtain underneath his seat, he was therefore Your Honor, search was conducted. Search was conducted by the police officer, and therefore this SI contacted the SP. Conducted the SP Lordship for the so that he can for further necessary action. Therefore, Your Lordship, later SIP Bhawa was he came there, Your Lordship, therefore he conducted a search and opened the plastic carrying bag and found one inverter machine, and opened the same, found suspected contraband kept concealed by him, or he was said to be by the accused, Lordship, but this is not true, Lordship, because since the accused went there for the repair work of the truck, not to carry any illegal consignment, Lordship. The accused has also vehemently opposed that what the police was saying, that the curtain was of the accused. He has vehemently opposed it, but the police did not hear a word of the accused. They, upon finding all this material from this curtain, Lordship, they told him that it has been brought by him from Silchar to Shillong so that he can sell the things, Lordship, which was kept inside the inverter. But this is not true, Your Lordship, because since this accused, he was just occupying that seat, and he was not aware what was kept under that curtain, what was kept inside, underneath his seat, Lordship. That was thing. And this accused, Lordship, he's just a daily wage laborer, and he's the only son of this petitioner, and he's the only earning member in the family. He have got his elderly parents at home, and a child and a wife also to look upon, Lordship. He is the only earning member of the family, Lordship. And I would pray your Lordship to kindly allow accused to release on because based on just suspicious of being carrying this carton, Lordship, he cannot be simply just accused to be the main person the main person who is dealing with this contraband, Lordship. The only fault of his was that he was sitting on that empty seat, Lordship. That was the main thing, was that, and he's not aware about what is there in that that brown carton which was kept underneath his seat, Lordship. And the main intention he went was just to repair the truck and come back home as soon as possible, because there was no one at home, only the elderly parent were there, and a child and his wife was there, Lordship. And due to all this thing happened, and now he's still stuck in the jail. He's just in the jail, Lordship, till now. Also from the 22nd of August till date, he's still there. And all the investigation of the police also have been done, Lordship. And charge sheet also have been submitted on Lordship, on 10th October 2024. It was already been charge sheeted, and the case is pending now for evidence, Lordship, in this special judge at Clearjat, Lordship.
Yes, Mr. Shulai.
This is your Lordship. Lordship, this is the 5th bail application, your Lordship. Fourth bail application were moved before the learned special judge. Those order passed by learned judge have not been placed on record, your Lordship, except the one which was filed on 16/12/24, your Lordship. Lordship, kindly see, your Lordship, in this case, your Lordship, the heroin was seized from the possession of the accused, your Lordship. He kept concealed in the inverter, your Lordship. If Lordship kindly see, kindly come to the charge sheet, your Lordship.
Page.
Lordship, kindly come to page 60, your Lordship.
Yes.
Lordship, kindly see preliminary test conducted.
Yes.
Conducting the preliminary test by using NDPS detection kit of the suspected contraband of yellow orange powder, which was recovered from the possession of Muhammad Siraj Ali. Lordship, the admitted fact is that it was seized from the possession of the accused, your Lordship.
Your Lordship, while seizing this
Lordship, the case now is under trial, your Lordship, and there are only 3 witnesses, your Lordship. Lordship, kindly come to page 59. The number of witnesses to be examined, your Lordship. There are only 3 witnesses, your Lordship.
Lordship, over here, this 2 witness, the independent witness, this witness were arranged by the SI in IO itself, Your Honor. The arresting officer also is the same, and they investigate.
We are not into that now.
Yes, Your Honor. But
what is the stage of the cases for? Framing of charge.
Yes, right.
Charges have been framed.
Actually, Your Honor, the charging, yes, Your Honor, has been framed. Yes.
When was the charges framed?
Yes, it was
Which
on.
date?
Lordship, I think she's not properly briefed, your Lordship. As per the CIS, your Lordship, is that the case is fixed on 30th, day after tomorrow, your Lordship, for appearance of the accused and for CC, your Lordship.
Because even before this, Your Lordship, on I think so on December.
Lordship,
also
kindly
was,
come to page 67 of the application, your Lordship.
Yes.
Lordship, Can you see, Your Lordship, the sentence seen the bail application of the accused was preferred only on 21/11/2000, where this court has dealt with in detail. Your Lordship, I got the order of this of that one. Your Lordship, can you see? Lordship, kindly come to next page, Your Lordship. Heard learned counsel for respective parties. Since that the case has been charged sheeted and placed before the court, Lordship, on next page down below, Your Lordship.
Yes.
Seen that the case has been charged sheeted and placed before the court on 16/10/24, and the copies have been supplied to the prosecution on so and so. However, copies are yet to be supplied to the accused, as his lawyer had not appeared and on the last date, and the same is fixed on 25/11. Then, Lordship, kindly see the finding of the learned special court, Your Lordship.
Yes.
Lordship, in this finding, Your Lordship, the learned special judge, Your Lordship, has taken into consideration, Your Lordship, the order passed by this honorable court, Your Lordship, in bail application number 22 of 23, Your Lordship, which, if Lordship kindly come to para 17 of that, Lordship, para 18 of that order, Your Lordship.
Yes. Yes.
In the case of so and so, Your Lordship, there is no doubt that the grant of bail is entirely the discretion of the judge concerning the case, but even so, the exercise of judicial discretion has been circumscribed by a large number of decisions rendered by this court and by every high court in the country. Yet, there is a necessity to interest whether denying bail to an accused person is the right thing to do on the fact and in the circumstance of the case. Taking a cue from this, and this court is reminded of a remark which ran as follows. The scourge of drugs yield disastrous consequences on the health of young people, the well-being of the family, the spread of crime, and the destruction of economies by financial flows of obscure origin. The above remark is true in the state that we are now living, where the menace of drug is threatening to destroy life and society. Indeed, young people are most vulnerable to this threat, and many a time have been seen to fall prey to the same. It is incumbent upon this as well as the court combat this menace in whatever possible way, and although due procedure has to be followed in drug-related, the investigating agencies and have to be given wide latitude in napping and bring any possible accused in book. Your Lordship, the record reveals, Your Lordship, that this drug he purchased at the rate of rupees 40,000, Your Lordship, and kept it concealed in the inventory with an intention to sell it in Shillong. The record reveals, Your Lordship, and even the finding of the learned special judge in the order dated 21/11/2024, Your Lordship.
What about the evidence of the IO? Whether he can link the accused person to the consignment?
Lordship, Lordship,
whether that consignment, indeed belongs to the accused.
The charge sheet reveals, Your Lordship, that this consignment, the heroin, Your Lordship, was seized from his possession.
The version of the accused is that he was a passenger in was it a bus or sumo?
Bus, night super bus.
Lordship, that is a matter of evidence to be. That is a matter of evidence, Your Lordship. So far, the investigation reveals, Your Lordship, as reflected in the charge sheet, that the drug was seized from his possession, Your Lordship.
But Your Lordship, I would
he is having a conscious. He was aware, Your Lordship.
Lordship, I would submit here that the IO and the arresting officer, seizing officer is the same person, Lordship.
That's
and the
a matter of trial.
Yes, Your Honor, but in this independent witness also, Your Lordship, were arranged by the IO itself, from that also from far place, not from that particular place, Your Honor.
Section 37 is involved here. Consignment is of commercial quantity.
Lordship is intermediate quantity.
But why have you preferred an application under Section 37? Look at your cause title.
43, Your Lordship, read with Section 37.
This what you can do. You can argue before charge. Charges have not been framed. Matter is posted for consideration of charges. You argue before charge, and the matter may be, if you have a case, the court will decide accordingly.
Lordship, there are only 3 witnesses, Your Lordship.
Anyway, that's
If
beside
charge is framed also, Your Lordship, I believe Your Lordship will not take much time, Your Lordship. He was arrested only in the month of August, August 24, Your Lordship. It is not a case of prolonged trial or a delayed trial or a prolonged detention, Your Lordship. Considering the gravity of the offence involved, Your Lordship.
But Your Lordship may grant bail if Your Lordship feel it is. I have got one citation, Your Lordship, regarding this. Your Lordship, in this order by this Orissa High Court, serial number 9, Lordship. The Honorable in this, they have referred to this Avtar Singh and others, Lordship. We also, Lordship, in the next page you can see the person who merely sit on the bag in the absence of proof or of anything cannot be presumed to be in possession of the goods. Page number 5, Lordship. So even here also a similar case, Lordship, in this matter also. The accused was unaware of the ganja. He was just traveling along with this, but the ganja was placed and he just sat on it. So based on that, it cannot be presumed to be
you place your argument before the court when the charges are to be considered. If the trial court finds that you have the prosecution has no case, you will be discharged. All these points may be taken up before trial court. Counsel for the petitioner or the applicant who has submitted that the applicant has approached this court with this instant application for under section 483 of the BNSS, read with section 37 of the NDPS Act, with a prayer for grant of bail to on behalf of Shri Siraj Ali, who is an accused person in connection with, what is the case number?
Siraj Ali, Your Lord.
No, case number before the special court.
NDPS
26 of 2024.
Criminal bracket NDPS case number 26 or 24, Your Lordship.
Before the special court, before the court of the learned special judge, NDPS at Cleariat. Cleariat is Giant Hills. It is the submission of the learned counsel that the accused person is the son of the applicant who was sent by the applicant to Silchar, Assam, in connection with a truck belonging to the said applicant, which is lying in a damaged condition on account of an accident which has taken place involving the said vehicle. Accordingly, the accused person had proceeded towards Silchar by public transport, and on completion of his assignment he had boarded boarded a bus under bracket Night Super from Silchar towards Shillong. This took place on 22/8/2024. Next, in course of the journey, the said bus was stopped by the police for routine check, and in the process the police personnel discovered a brown cartoon box lying under the seat of where the accused person was sitting, and finding it of suspicious nature, the same was checked. Inside the box was found an inverter, and on further check and on further examination, it was also found that it contained consignment of contraband substance. Where's the seizure list? Seizure list?
Seizure list in page number 30, Your Worship.
Belum tahu. Suspected contraband substance being yellow orange powder of weighing 79.81 grams, the same on being tested revealed to be heroin. The accused person was accordingly arrested on the ground that he is found to be in conscious possession of the said consignment. On the case being on an FIR file by SI like Pars EM of Ratashera CP capital C dot P East Dainty Hills. A case was registered being Bloomstone PS case number 32 under bracket 8 of 2024 under section 21 under bracket B small b oblique 29 NDPS Act. On investigation being completed, the charge sheet was filed, and the matter and the IO had forwarded the accused person to the competent court of jurisdiction for trial. The stage of the trial is for consideration of charges. The next date fixed for the case is, when is the next date?
30, Your Lordship.
Is 30th January 2025. it is the further submission of the learned counsel that the accused person is a mere passenger and has no knowledge of the said consignment or box which was kept under the seat he was sitting, and as such he could not be, and as such the prosecution has falsely implicated him in this connection. In this regard, the learned counsel has also referred to the case of Kishore Bira versus State of Odisha, wherein the Honorable High Court of Odisha in BLAPL capital no BLAPL number 9629 of 2021 at para which para you referred to at Odisha case? Para 9. At para 9 of the same had cited the case of Avtar Singh and others versus State of Punjab, wherein the Honorable Supreme Court inter alia had observed I quote more, the person were merely sitting on the backs, comma, in the absence of proof of anything more, comma, cannot be presumed to be in possession of the goods. Close. It is a similar situation as far as the case of the accused is concerned. Further submits the learned counsel, and on this ground, at this point of time, it is prayed that the accused may be enlarged on bail on any condition that this court deems fit to impose. Per contra, Mr. N.D. Shulai, learned AAG, along with Mr. Learned Counsel, learned G, while opposing the prayer made by the applicant, has submitted that the applicant had failed to reveal the complete facts and circumstances of the case of the accused, inasmuch as about 5 bail applications have been preferred before the learned trial court, which were rejected on merits. Therefore, there will be no change of circumstances at this point of time. The accused may not be enlarged on bail. It is also the submission of the learned AAG that the case involved contraband substance, comma, contraband narcotic substance, that is heroin, which is very serious in nature, inasmuch as the drug related situation and scene in the state is very serious and in a dismissal it's very serious and needs to be combated by all concerned. That is the enforcement forces and even the common citizen, as well as the courts of justice. In this regard, the learned AG has referred to the case of Shri Kuplian Sum versus State of Meghalaya, wherein by order dated 31/7/2023 in BA number 22 of 2023, this court at para 18 and 19 has 18, 19 and 20 as observed as follows. It is also the learned submission of the learned AG that evidence would reveal that the accused person is involved in the case and as such has to be tried for the offence committed. This being the case, at this stage this court may not release the accused on bail, and this petition may be dismissed as such. This court has considered the submission made by the parties. The facts need not be repeated, except to note that the accused person in question is facing trial in an offence under the NDPS Act. Needless to say, the offence is serious in nature and needs to be dealt with in strict compliance with due procedure and law. As far as the reference of the learned counsel for the petitioner to the case of Kishore Vira Supra, this court is in agreement with the observation made by the Honorable Supreme Court quoted therein. However, the key word in the quoted portion to be noted is the word proof. I quote PROOF. As far as proof is concerned, at this point of time, this court cannot come to any conclusion as to whether there is any proof for or against the accused person in question. It is a matter of trial where evidence has to be led in this regard. Be that as it may, considering the submission of the learned AG, where they submitted that there are only 3 witnesses in the case which can be presumed that the trial may not be prolonged unnecessarily. Therefore, it would be just and proper for the prosecution to prove its case, and similarly for the defense of the accused to disprove the charges. It is also the observation of this court that this case before the trial court is for consideration of charges, the accused is also given the opportunity to state his case before the trial court before consideration of such charges, and necessary orders will follow as to whether he is liable to be discharged or not. In view of the observation made herein above, this court is not inclined to allow this petition at this point in time. Petition is hereby dismissed.
Apply, Your Lord.
Take your chances before the trial court.
Yes, gotcha.
From daily list, item number 1.
Lordship, in this matter, I am having one prayer, Your Lordship. Just I got the information one that's earlier I filed my affidavit, Your Lordship. So there is some correction is required. So I may be allowed to file the additional affidavit, Your Lordship. Without permission, I cannot file.
You withdraw your affidavit and file a fresh one, or you?
So, Your Lordship, this
Additional affidavit means the earlier affidavit is complete in all respect. So you will file some additional facts or whatever.
some changes will be
But now,
required.
if you want to change the affidavit that is already
It is
filed,
required to be changed, I believe.
then you have to withdraw it.
So, Your Lordship, I will do this.
Mr. R. Learned CGC has submitted that the affidavit in opposition on behalf of the respondent 1 and 2 has been filed. However, inadvertently, errors have occurred in some of the amendments made therein, for which the learned CGC has submitted that he may be allowed to withdraw the said affidavit in opposition with liberty to file fresh affidavits. We allow. What about 3 and 4?
They have already filed.
Have you filed your rejoinder?
Rejoinder, we had forwarded a copy which sir had given us on the last occasion. We were still awaiting proper instructions, Your Honor. But since my learned senior is saying that he will be filing.
That is for 1 and 2.
Yes,
for
for
3 and 4.
3 and 4. It was almost similar, my lord. Almost similar.
So you have not filed yours.
Not filed it yet.
Then a counsel for the petitioner has submitted that the rejoinder to the counter affidavit filed by the respondent 3 and 4 could not be filed today, and has wait for some more time for the same. Pray aloud. This is matter up to 3 weeks.
It's obliged.
So, I will be allowed to file, Your Lordship. I will be allowed to file the fresh.
Yes, that's only. Your petition will be accordingly. The said affidavit filed by the respondent 1 and 2 is deemed to have been withdrawn.
Much obliged.
Item number 2.
Lordship, praying 2 weeks time to file the affidavit.
Lordship, I'm entering appearance on behalf of respondent 4.
Who's respondent 1?
1, 2, 3 is
1,
the
2, 3
district council.
Mr. Dengdo is appearing.
So you have 4. Mr. R. our Learned Counsel for the respondent number 1, 2 and 3 has prayed for some more time to file the counter affidavit. Mr. Learned Counsel has submitted that he is entering appearance on behalf of the respondent number 4 and has also prayed for some time to file the counter affidavit. You file your power?
Lordship, I've already tried.
As prayed for? Bring on a thought, pray aloud. Pray aloud. This is matter 3 weeks.
Obliged.
Item number 3.
This is that matter, my lord, concerning place called RR Colony, my lord. This place, my lord, the basic grievance. But before I start, my lord, I don't know if all the respondents are properly represented, my lord.
You're asking for time?
Please, miss, don't come with that kind of submission. You are not supposed to presume. A matter is listed. It's listed for certain purpose, either for orders or otherwise. It has to be taken up. You have to be prepared.
Did you say that?
If you are not prepared, you say so. If you are, then you do it. But don't presume and say that it's contingent on the behavior of the other counsels. All the respondents say you are 4 and 5.
Darbar Snong, my lord, is still unrepresented, I guess.
Darbar? You want to explain? Respondent number 6. Request number Frinja also is a party in this case.
Who?
That has already been proceeded ex parte. Request number Frinja.
Yes. It has proceeded ex parte.
Ex parte.
So all the respondents are
Yes.
in attendance there.
My lord, today, my lord, Senior Counsel Mr. Kinta is not there. Otherwise, my lord, Darbar Snong, as against Darbar Snong, my lord, the matter is ex parte.
Oh, we will proceed. We cannot wait any longer for any.
Maybe, Lordship, we can all agree, and maybe after a week or two, because this matter has been coming time and again, and an issue of power of Darbar Snong. So KCD is a very relevant. State has got limited role, Lordship, but so far state is concerned, they have to clarify the position. Because it's going to lay down a precedent at least, and has wide ramification. It's not a normal litigation, Lordship, but questioning power, functioning, Darbar Snong. So most of the Darbar Snong will be affected. So Mr. Senior Counsel, Mr. Kinta, is that at least he can assess the court and
Mr. Mauri, Learned Counsel, has submitted that the Learned Senior Counsel, Mr. G.K. Kinta, who is also the Special Counsel for the respondent 4 and 5 of the KHDC, could not be present in court today on grounds of personal difficulty, and as such accommodation is sought for the day. Similar prayer is also made by the petitioner through Learned Counsel Mr. S. Thapa. On consideration of the prayer made, the same is allowed. Place this matter after 2 weeks.
Item number 4.
Lordship, this is the Lokayukta matter challenging the order passed by the Lokayukta, Lordship.
This connected to
Lordship, yes. In fact, it appeared that today's cause list, the connected matter which was filed by the state, has been put in the roster of the coordinate bench, Lordship. So we had made a joint mention before the Honorable Justice Bhattacharjee that we will be filing an appropriate application before the registry to have both the matters tied together.
Why was it?
Perhaps, Lordship, was probably because of the reshuffling of the roster or something. Year-wise, it was segregated.
Year-wise?
Perhaps, Lordship. but it was otherwise because challenging the same order, more or less on the same grounds.
That was of the year
2021, Lordship.
2021.
Lordship.
But this also 21.
Yes, this was reflected as part heard. Maybe that's why they have kept this here.
No, but I think this court is
Lordship, because matter
taking
was
up
heard.
matters of 21.
Lordship, some issue with the
Maybe some
cause
mistake
list,
must
yes,
have occurred.
yes. So we have from the other bench, Lordship, they have given us liberty to file a application before the registry to have it clubbed together.
On pre-made by the parties, let's this matter up to 3 weeks.
Much obliged.
Bumdan ba apia hi. Sorry.